The plaintiff's motion for interim parenting time schedule, substance abuse evaluation, and therapist for the minor children. I have read the motion, the response, and the reply to the response. I spent quite a bit of time going over this file, so you don't need to repeat everything that you have. All right. And Ms. Satter?
Good morning, Your Honor. Nasli Sater on behalf of the plaintiff, Andrea DeVos, with my partner, Rick Rohn, who will be arguing today.
Okay.
Good morning, Your Honor.
Thank you.
Thank you.
Would you like us to proceed?
Yes, please.
Thank you, Your Honor. I know that you read everything that comes to you, and so far there's been a mountain of materials provided. Based on the challenge to the veracity of our client's sworn statements, I'd like to ask the court to swear Ms. Abraham, if you would, please. I have 3 questions to ask her.
Okay, I will allow that for a brief time.
Thank you, Your Honor. Andrea, in preparation of our motion, did you participate in the preparation of the verified motion and your affidavits?
I did, yes.
Did you carefully read everything that's been ascribed to you?
I did, read and edited.
Thank you. And do you affirm today before Judge McNabb that the 3 statements that you've provided contained in the verified motion, in your affidavit, contained in that verified motion, in the verified reply to the defendant's response, and your additional affidavit in that verified reply, those were dated October 11, you read and affirmed that those are true, correct?
Yes, I do.
Your Honor, I have no other inquiry of Ms. Abraham on the veracity of her statements. I would like to point out, and I don't want to repeat everything that's in our motions because I know you read everything, but I would like to point out the highlights of this case. For 2 years, the parties have been separated. This is a case that's been marred. The family's been marred by domestic violence, 2 significant assaults in 2 years, prompting both of the filings. The filing 2 years ago for a domestic custody case in Michigan, and then there was a companion case or a competing case in New York where the parties also had a home. And then the case filing this past June, which is the divorce action. The domestic violence has led to, as the court knows, to criminal charges pending against Mr. Abraham. And while the party is presumed to be innocent until proven guilty, in this case, there is a history of domestic violence. Those charges are pending, and this has had a significant impact on the party's attempt to reconcile. Ms. Abraham went to great lengths over the last 2 years when the parties have been living separate the entire time to try to reconcile and to try to make this marriage work, but she simply cannot put up with the behavior that's happened here. 2 years ago, before Judge Gottlieb, mother was awarded temporary custody of the children, and father was awarded limited parenting time out of a need to protect the mother and the children from these behaviors. In the fall of 2021, the parties reached a settlement agreement, and they operated under that settlement agreement, which provided mother had primary custody by father's agreement, and father had 2 evenings each week for dinner and Saturdays, no overnights. Since June of 2021, the parties have lived in 2 separate households, both in East Grand Rapids. Settlement agreement was signed in 2021, and the parties operated under it. And by its own terms, it ended in November of 2022, but the parties continued to follow those terms and that schedule essentially. Now, mother has been accused of alienating the father and trying to cut off the father-son relationship, but that's simply not true. By her own behavior, by her actions, and by the calendars that we've submitted to the court, mother has agreed to additional time beyond their agreement. And so for the past year, including last school year into this school year, father has had an average, based on our calendars that we've submitted, an average of 6.5 overnights per month. And that's more than what was provided in the settlement agreement from 2021. And while there's a dispute between the 2 calendars, we painstakingly went through Ms. Abraham's calendars. She went through photographs in her photo albums digitally to verify, based on date and timestamp of the records that she has, to verify the calendars that we've provided to the court. And so to the extent that the court has looked at the calendars and there's some dispute as to when the father had parenting time and how much it's been, Ms. Abraham is representing through me today that for the last year, father's had an average of 6.5 overnights per month. That was during the last school year. This is a reflection of the mother's cooperation and her encouraging this father-son relationship. When she filed for divorce this past June, somehow she's been criticized in her statements to the police officer who was investigating that somehow she was planning the divorce. I know the court is aware that victims of domestic violence struggle with leaving their abusers. They stay to try to work things out. Clearly, mother chose to end this cycle by leaving after trying for another 2 years while the parties were separated. There's nothing wrong with that. The parties have engaged in 6 sessions of partial mediation since June filing. We've got a very qualified mediator on the other side of the state, Carrie Middleditch, who has been working with this family. These were not 6 full days of mediation. Some of these were an hour session or more. And we believe that additional mediation can help resolve many of the issues that are facing this family. But we simply were unable to reach an agreement regarding the custody schedule. And what has happened in the past several weeks has pretty much been a free-for-all, where instead of keeping the children on what we understood to be the scheduled time, Father would keep them over on some Sunday overnights, which during the school week is very, very, very difficult. And so there's been a race to the school to grab the children based on the misunderstanding of the schedule. And so one thing that we're asking you for today, Your Honor, as you fashion a parenting schedule, is to reflect on the calendars, rely on the schedule that we've had with 6.5 overnights per month. This has never been a 50-50 custody arrangement, which is what the father is asking for. And we're not asking for a 50-50 arrangement today. We're asking for a schedule that will provide stability and predictability for these children and for the parents, so they know clearly who has the children on which day. This is nothing unique to any of the cases that the court is faced with. Your Honor, with regard to the substance abuse and rehabilitation, the substance abuse testing that we've asked for, in the July 18th agreement, the father did agree to testing, but there may have been partial testing. There was no hair testing. We don't believe that the testing was done at U.S. labs. We're seeking an assessment based on the fact that a year ago, father spent a month in rehab to the tune of $95,000. That was Exhibit 7, or exhibits toward our motion here. That he admitted to Ms. Abraham that he used prescription drugs and kratom, that he admitted that his friend Mateo Sola is the one whom he acquires drugs with. In Exhibit 6, we see the payments made to Mr. Sola over the past several months, ending earlier this year. And in the response that Ms. Guadaluco filed, it's rather puzzling why Mr. Abraham, who lives on a $10,000 per month allowance provided by his wife, in a several-month period, spent almost 20% of his allowance helping support this Mr. Sola, who he claims is not his drug dealer. Most disturbing about their response is the 3 statements where he spent $2,800 on March 3, April 7, and May 15 of 2023, payments to Mr. Sola to check on the apartment in New York. The parties have an $18 million apartment on the 20th floor of a luxury building guarded by a doorman with a very sophisticated entry and security system. And after reading this response, we pulled the records. We don't have them as an exhibit that we provided ahead of time, but we can screen share them. And the access code from January of this year going forward does not show that Mr. Sola had any access to the apartment. He was not authorized. Mr. Abraham did not have authorization to allow anyone to enter the apartment. And frankly, Your Honor, we believe that this statement from Mr. Sola, which is not notarized, which has no affidavit, is a fabrication. And more disturbing, as we tried to track him down to serve a subpoena for a deposition, we learned that his address that he stated, where Mr. Sola claims he lives, is a U.S. post office. And unless he's the postmaster in this little town, that's a P.O. box. So we believe that that response is a fabrication, which goes to the issue of credibility of these parties. We believe that it's imperative under Factor G of the Child Custody Act, the mental and physical health of the parties, that the court has the information necessary to assess the mental and physical health of the parties of Mr. Abraham. And in light of his month in rehab a year ago, in light of his admission to using kratom and prescription drugs supplied by Mr. Sola, he's made those admissions to his wife. We believe that it's important that the court be provided with those facts and that medical information. Now, Mr. Abraham asserted his right in his medical privilege. He doesn't want to turn over the records. If you do that, then the court can draw a negative inference based on the medical information that you refuse to produce. The father, in this situation, Your Honor, I do believe that you have the authority to order substance abuse and drug testing, and you have the ability to make that testing and a clean test be a condition of the parenting time. So we're asking for that. Finally, with respect to communication between the parties, due to the pending criminal case, there's a no contact order, and that was our Exhibit 5 of our motion. The parties can communicate regarding issues limited to the children only, and some attempts have been made. But the communications by text are not effective if they're not answered. So one remedy to that would be to use Our Family Wizard. We do agree to that, that each party use Our Family Wizard. The problem is when father texts and there's text communication when he's going to pick up the children or receive them, but when it's time to return them, there's no response, and that's problematic. We believe that father has violated this bond condition. Exhibit 5 is the gift that he sent through the children during a child exchange to Miss Abraham, a violation of the bond that had a message in it, a cryptic message made on a label machine that says, "Find a secure way for us to talk, and I will consider it." That's a bond violation. We don't know what the prosecutor is doing with that, but we do know that we have a prosecutor who carefully considered the charges in the domestic violence claim and when he brought the charges. Now, Ms. Guadaluco would want the court to believe that Chris Becker, our prosecutor, is corrupt because somehow her family was able to persuade or urge the prosecutor to bring charges against Mr. Abraham. This is a domestic violence case, and the prosecutor and our justice system in Kent County is not corrupt. And so those pending charges are there. They impact the communication between the parties. There are certain limitations, but we can work around that. Finally, we're asking for the court to assist in the selection of a counselor for the children. There was a recommendation for a counselor. There was a recommendation for the parties, for Ben Burgess with Fountain Hill. Taylor Broadbeck would be appropriate for the younger child. Dr. Amy Jarchow would be appropriate for the older child. Dr. Jarchow is through Human Resources Associates. And at some point when the parties are able to be together in some sort of joint situation for parenting purposes and to help deal with a lot of the conflict in this case, it would be appropriate perhaps that they work with Ben Burgess at Fountain Hill. We can't obviously have an order for that right now when there's the no contact order. So in final summary, Your Honor, we're asking for a parenting time schedule that provides father with parenting time on Fridays after school, on alternating weekends, Fridays after school, or if there's no school until 4 p.m. until Sunday. That would be the alternating weekends. We're asking that the court continue the Thursdays weekly. It would be for a dinner preceding Mother's Weekend. It would be for an overnight preceding Mother's Weekend. It would be for a dinner preceding Father's Weekend. That would provide a 4 out of 14 schedule, which is more than the average 6.5 overnights per month in the past school year. If the court thinks that a little more time, perhaps every Thursday overnight would be appropriate, that would give father a 3 overnight weekend. And that would provide about 8 out of 8 overnights on a monthly basis. And that's more than he's had in the average. We think that it's important that the children are in mother's care every Sunday evening so that we don't have a weekend with father that goes over into Monday. As we showed in our exhibits, Exhibit 8, a child fell asleep as soon as he came back from father. It wasn't bedtime. The activities, the lack of structure, particularly is problematic when the children are facing a school week. And so the consistency in the past 43 Sundays, over the past year, we looked at the records in the calendar, and 36 of them, or about 78% of the time, was Sunday overnights with mother. Father has not regularly had Sunday overnights, and that should not continue. Thank you, Your Honor. I know this has been lengthy. If the court has any questions of me, I'm prepared to respond. Thank you.
Thank you. Ms. Badalucco.
Thank you, Your Honor. Marie Badalucco here on behalf of Mr. Abraham, and my co-counsel is also present. If she wants to state her name for the record, I don't believe we did that quite yet, Your Honor.
Emily Long, co-counsel for the defendant, Mr. Abraham. Thank you, Your Honor.
Thank you. Your Honor, that was a lot. That was a lot. And I think what it really rises and falls on is, what does the calendar say? What have these parties done? How have they acted? How have they behaved? And whose care have the children been entrusted? And the answer to that is father's. And the answer repeatedly is that it is father's. And perhaps I've overlooked at it. And they did submit to the court a reply brief, which is in violation of the court rule, but they did. I don't know if the court invited it, but they submitted it. And I did review it. I also reviewed their initial filing, and neither of those documents that I reviewed, including the lengthy exhibits that were attached to each one of those 2 filings, demonstrated anything in the way of calendars except for 2 pages. And that was August and September of this year. So if I overlooked it and someone wants to correct me, please tell me. But I tried very carefully to review every inch of material that was submitted to this court on behalf of Andrea DeVos Abraham. And what I found is that there is simply no proof. There's a lot of pontificating. And what I submitted to the court was a verified pleading that my client, having reviewed his GPS tracker on his own vehicle, having reviewed his own photographs, timestamp, date stamp, giving them to me, turning it all over. It took hours upon hours upon hours to verify these calendars, Your Honor. We did not lightly submit our calendars to this court as part of our exhibits. And what you see in their reply is something conspicuously absent: calendars, proof. Pontificating will not cut it. And I'm going to submit to the court that what they've submitted to you is simply a fallacy. Mother does not conduct the time that she claims that she does. My client has substantiated the proof by way of the records from his Range Rover, by way of the time date stamp, and by way of materials that we verified for the court. So what my problem is this: it sounds like Andrea DeVos has a nanny or 2 on call and available. And so to the extent that she is conducting time, my understanding is that she is offloading some of that time to those individuals, including bringing them to the school. And bringing them to the school is a 2-person job, except in some, because of her having decided that they should be at these 2 very disparate schools. One being Journey Academy, which is in no way nearby where the Montessori school is, where the younger child attends. And so when father drops off one and he drops off the other, he comes in at the end of the time to drop off at Journey. Mom complains about that in her filing, but that's what they've always done. And if you look at my client's GPS records, you'll see he was doing those drop-offs this year. So if she's complaining about that now, it wasn't a problem until such time that she decided to file for divorce. So now that she has submitted her divorce filing to the court, a number of things seem to be a problem that never were before. And so if I should go in order of these items that they addressed before the court, I certainly can. I'll start with the domestic violence. So what I see in their reply is it highlights the domestic violence. And what's interesting about this is that the 2021 case that was instituted in both Michigan and New York started with a claim of domestic violence, that he was throwing her over a balcony. The truth is, and this was stated in all of the filings in New York, is that she threatened to throw herself over the balcony, swung her leg over the balcony, was screaming, ranting, and raving while doing so, and in fact was regularly under the influence of drugs, including marijuana, on a regular basis. My client, if you swear him in now, will tell you that at least 10 hours per day, she was using marijuana, or she had marijuana in her system. And that increased during the night hours. Now, thankfully, they had a nanny who was on hand, including this Cecilia Celebrato, whose affidavit you see attached to their reply. However, that individual, if the court is, as a side note, looking at the Mateo Sola spendings, that individual, Cecilia Celebrato, received $17,000 from my client's American Express card that was never repaid to him. And she had at that time stopped working for them as a nanny because she was having health problems. So there is $17,000 that my client was on the hook for, and here they are complaining about $16,000 to another individual. So they're, and I don't really even know why we're fighting about $16,000 or $17,000. I don't think that that's important for what the court is looking at. If they're saying Mateo Sola cannot be found because they had a mailing address for him instead of a physical address, why they would not email me and ask for a physical address where they could serve him, I don't know. That's a question better left to them. They're the ones who filed the reply. The first time they're raising it is right now before your honor, instead of raising that in their reply, which was improperly filed anyway. So, but back to the point about the domestic violence. The domestic violence in the initial case was alleged. And then the next thing that happened is she kidnapped the kids. She took them from New York and took them to Michigan, kept them in her parents' home. And when my client tried to visit with them in the home in Michigan, he was kicked out. And he had to go be relegated to another residence so that he could see the kids in drips and drabs as the plaintiff decided was appropriate. And then the third thing that she did after she did those two things was she said, oh yeah, and he committed domestic violence. Well, here is really no difference. What happened on August 25th is she became irate, she became irritated, she threatened divorce in front of the kids. They spent the night together that night as a family, their last one of its kind. And then she kidnapped the kids for 10 days and for 15 days in May and in June. And she prevented him from seeing these children for large portions of time. And in the meantime, she was working on getting the prosecuting attorney's office to issue charges against my client, which they ultimately did. Please make no mistake, Your Honor. I am in no way, shape, or form suggesting that the prosecuting attorney in Kent County is corrupt in any way. Period. Full stop. What I am suggesting to this court is that Andrea DeVos is using the system as she previously did. And last time when she used the system, what she learned is she had a jurisdiction problem. And as soon as she found out she had a jurisdiction problem and she was going to have to answer for that ex parte order that she got in relative to the custody and parenting time that was allotted. She was told by the court in New York, come back to New York within 14 days and we are going to adjudicate the claims that you have made in your Michigan court. And as soon as she got wind of that, what did she do but raise the white flag? And she immediately, that next month, signed off on a settlement agreement. My client, for his part, only reason that he signed off on that settlement agreement, and if you swear him in, he'll tell you that now, is because he was desperate to keep his family intact. However, for them to now hang their hats on this expired settlement agreement, and the court can see from its terms that it expired exactly 1 year later. More importantly, they never followed the terms relative to parenting time. So this court is in no way, shape, or form beholden to an expired settlement agreement that they continue to parade before the court. I don't understand why they continue to bring that to the court, except to cause you to lose sight of the fact that is what their parenting time truly was. And what their parenting time truly was is exemplified in the calendars that we meticulously prepared and attached as exhibits to our filings with this court. And what we see from that is that the father actually had more parenting time than mother did. And in fact, in February 2023, he exclusively had the children for 15 days. In March, for 15 and a half days. And you see why it's a 15 and a half. I can explain more if the court should desire. But the point is, Your Honor, my client regularly, methodically was ensuring that he had a close bond with these children. And what they're presenting this court with is to somehow strip him of that ability, which they've already tried in May, unilaterally, which they've already tried in June, unilaterally. And we are asking that the court not permit it. If the court is going to change the custody and parenting time so very dramatically, then we are going to ask that the court please conduct a hearing for us to submit to the court the best interest factors for it to make that determination. If the court wants us to continue mediation efforts, absolutely, not a problem. Yes, we broke down in terms of the mediation efforts, but it is completely false to say that it is my client's fault. The other thing is that the person who went running to the school on Monday, October 4th, I think it was, 3rd, it was in the filing. The person who went running there was Andrea DeVos, not my client. She ripped one kid out of the school early and had her nanny and security team rip the other kid out of the school early at the same time. And why did she do that? Because she did not want to honor the agreement that she made by text message with my client. On the subject of communication, I think it's critical that the court understand that on June 23rd, I sent a letter to opposing counsel and I asked that we please use our family wizard. There's a calendar option, there's a texting option that you can use through the app. It's a perfectly transparent way to communicate. It seems like it made good sense. And I'm perfectly happy to have the clients, our respective clients, do that. What I'm not happy with is an attorney writing the text message for an individual, sending it to my client to try to entrap him. And again, I know the court read the filing, you saw that they in fact did try to entrap him last week. They told him she's not at the school, so there was some confusion on Thursday. He was not expecting to have hearing time on Thursday. They said, take it. We said, well, we'd like to do this other schedule. So what did they do? They played a game of chicken. And even though Andrea DeVos was at the older child's school, she had no intention of bringing him home with her, apparently. And so then we found out that the younger child's school called my client and said, hey, nobody's here to pick up the younger child. Will you please come for him? So that's why my client picked up the child on Thursday, not because there was some sort of, he was trying to take an extra day. It was because she did not pick up the child. I agree with counsel 100% that what we truly need is a schedule, but it cannot be one that is on this ad hoc basis by text messaging that her attorneys are writing for her, sending to my client. They're inappropriate. If he were to respond in the same form and fashion that she writes to him, he would be in bond violation. So this has to be very carefully monitored. I'm not comfortable with the way that the communication has gone on between the parties. And I will tell you one reason I'm very concerned about it is that Ms. Abraham has her legal team present at the criminal proceedings, each and every one. They show up, and at the district court level, they try to make a record relative to parenting time. They had no standing, but there they were trying to talk about parenting time. This court has jurisdiction clearly regarding parenting time, but for whatever reason, they're using the system in ways that are inappropriate, just like they did back in 2021. So, Your Honor, my request is in terms of drug testing and alcohol testing, my client did do a hair test. I've seen nothing from Andrea DeVos to demonstrate that she has done a hair test. What I have seen is some positive results. That's what I've seen. And so I'm not sure exactly what would be reflected in Ms. DeVos's hair test because I haven't seen that. I know my client's hair test is negative, and I'd be happy to tender that to the court in camera. So I just want to be clear, and it's a 60-day look back. My client has no problem with OFW. My client has no problem with texting, but it should be mutual. And it should be mutual for the reasons that are cited in my brief as well as, or my filing, as well as oral argument today. I have no problem with considering counseling. We should absolutely go to pick the right counselor though, and that has been something that we've been under discussion with our mediator. I would like to resume that discussion with our mediator if the court would permit it. My concern is, and counsel is shaking her head, and I understand, I mean, we would like it to start too sweet as well. But the problem is this, some of the individuals that they're suggesting, there are connections in ways that we're not comfortable with. So it can't just be that they're picking somebody where there's a connection. But I have no problem with that, nor does my client, obviously. So in terms of the calendar, however, my client is trying to be the reasonable one here. He is saying, let's do an equal parenting time and allow both of us to continue our bond with these children on an interim basis. That is a deviation from what he has enjoyed in the past. It is a deviation significantly, in fact, because as you can see, he used to be with the kids the majority of every single month, not as they're suggesting 6.5 days. I don't even know where they come up with it, and they didn't submit it in any of their hundreds of pages of filing. So what I'm suggesting to the court is that my client is willing to be reasonable and do a 2-2-3 schedule so that they're not apart from these two children for any length of time. If the court thinks that a better schedule for equal parenting time is more appropriate, absolutely, please. However, what he's not agreeable to is some significant change that is going to impact the bond that he has with these children. And that is why I'm asking for a hearing if the court is going to even consider that. Thank you.
Thank you. Mr. Roan.
We've heard from Ms. Badalucco in her argument a lot of speculation and conjecture, a lot of supposition. I have no idea why she accuses us, Andrea's attorneys, of writing her text messages. We certainly communicate and consult with our client intensely on this case. But such conjecture and such speculation doesn't have any place here. It's really offensive. Let's focus on what's important here. We heard virtually nothing about the rehab and the drug use on Mr. Abraham. He claims he's got a negative test, but now she says, okay, let's have testing. Let's have mutual testing. Ms. DeVos didn't spend $100,000 in rehab last year. Ms. DeVos didn't conceal or refuse to provide the discharge plan and the conditions of rehab because she wasn't in rehab. It's not mother who needs the drug testing. It's father who needs the drug testing. It's not mother who is the perpetrator of domestic violence. It's the father. And it's very easy to deny the domestic violence. But this is the second time, and now he's facing criminal charges. Those are very, very important factors under the Child Custody Act. And for Ms. Badalucco to ask for a 50-50 schedule and say, let's continue it, it's not a continuation. We're not asking for any change in custody. Here we're asking for a custodial schedule on an interim basis that reflects the past pattern in history. And I just heard Ms. Badalucco say fathers had the majority of every month, and that's simply not true. We know that you need to make a difficult decision here. We know that it's a temporary decision. And we're asking the court to make a decision that is reflective of all of the facts in this case and the trauma that these kids are going through and as impacted by the domestic violence, the communication problems. I don't know why we can't simply pick the counselors and to suggest that somehow we, our team, her lawyers, Ms. DeVos has some connections with Human Resources Associates and with the other counselor we suggested. I have no idea where that accusation comes from. I know of no such connections. Please, Your Honor. We're ready for an order. Thank you.
All right, thank you. This is a motion for a temporary order. This is the beginning of this case. I understand there's a lot of history here. The parties have been separated for quite some time. But again, this is a temporary order. There are lots of factual disputes about who did what when, even down to what the status quo schedule is for parenting time. The court has no interest in trying this case twice. So the point of a temporary order is just that it's temporary to get the parties to the resolution of the case. So having said all that, I think about the best interest factors, there's serious concerns regarding domestic violence. I'm not finding that it happened, but there's certainly enough to make this court very wary of that particular factor. And that obviously would, given the information that the court has at this point, that factor would go to the mother. Also, concerns about substance abuse. I'm hearing, frankly, concerns about both parents regarding substance abuse. Some more significant concerns regarding Mr. Abraham. And again, I'm not finding that any of this has happened. That's really what's up for a trial, not only here but also in the district court with the criminal case. But I have to do something in the interim, and so I will find that at this time that factor favors the mother. I'm going to require, given the concerns, I'm going to require that both parties submit to hair follicle tests that are approved by the front of the court. And I will refer this to the front of the court regarding custody and parenting time. Obviously, the court does not have the time to delve into all of this in frankly, in detail. And as I said, many factual disputes. I heard agreement regarding counseling for the children. Frankly, any children whose parents are going, or any child whose parents are going through divorce can benefit from counseling. That's just a no-brainer. What I'm hearing is there may be a dispute regarding who those counselors are. I would ask that the parties deal with that in mediation. If no agreement is reached, certainly this court will make a choice, pick a counselor, but I would hope that the parties could do that on their own. I think it's important that the counselor be independent with no question of any kind of influence by either party. Our family wizard, I heard an agreement regarding that. I do have a template order that I usually use, but if the parties have one that they can agree on, then I'm happy to sign whatever order that the parties would agree. Do you need my template or do you want to come up with your own?
I'd like to use your template order, please, Your Honor.
Okay, then I'll have Ms. Van Oler send that to you.
Thank you.
As far as parenting time, neither party is to consume alcohol or use any kind of substances during parenting time. I will set father's parenting time every Thursday overnight, alternate weekends from Friday at school pickup until Monday at school commencement. If that does not go well, if the children appear to be struggling on Monday mornings, then certainly this court would entertain a motion to modify that schedule. But I want to see how that goes. I will require that the father submit to random drug and alcohol testing at least once a week.
Your Honor, is that mutual as both parties, neither party is to have alcohol or substance abuse?
Yeah, I'll make it mutual once a week and share the results with each other.
Thank you.
And does the court need to pick a provider for that?
Yes.
Right?
Thank you.
What are your suggestions?
US Labs. I think they're in Coopersville. Court's familiar with them, I think, unless the court has another recommendation.
With them?
One, we had our hair test. I can't remember that one. But that one, can we maybe talk to our mediator about picking that as well as the counselor? I mean, on a basis.
Your Honor, if the court would select the most favored lab.
Okay, I'll have to get back to you on that. So I will check into that.
Can you get back with us through Ms. Toller, so that, because we may not be back in mediation for weeks and.
Sure. Yeah. No, I will.
Great.
I will.
Okay, thank you.
I need to check around. I have some thoughts, but
Great.
I'll do that.
Thank you, Your Honor.
Anything else?
Your Honor, we didn't address, because I didn't argue for alternating holidays, and we are approaching the holiday season. So I'm hoping that other than an alternating holiday order, we can address in more detail the upcoming holidays in mediation.
Okay.
Your Honor, I think one of the requests in our motion had been the substance abuse evaluation in light of the rehab that father had undergone. Would the court be inclined to order a substance abuse evaluation of Mr. Abraham with an evaluator selected by the court?
I was just going to say, I both parties at this point, I would ask that they would both submit to a substance abuse evaluation.
Perfect. And Your Honor, I know that we have attempted through the various mediation sessions, Mr. Rohn, myself, and opposing counsel, to land on a therapist. And there has not been an agreement coming out of mediation 6 sessions. We do believe that the child, the older one in particular, is in need of therapy. And we would really appreciate if the court would select that therapist for us. I know that going back to mediation takes us back a 7th time trying to address that issue.
I think the court just ruled that we are to go to mediation to select one who is independent and there is guaranteed no influence by either party. And I'd like to do that for a variety of reasons. I stressed that in my oral argument. And I hope.
Okay, all right. I don't want to delay this too long because the child, it sounds like, as I said, children in general whose parents are going through divorce need counseling. So I don't want to delay this too long. Instead of that, if both parties want to submit a list of therapists to me, and then perhaps and exchange the list and then list why you may not believe a certain therapist is appropriate, I'll make the decision.
That would be great. Thank you so much.
Probably will be faster. Can you give us a deadline on submitting that list, please?
Let's see. So 2 weeks.
Okay.
Thank you so
Your
much.
Honor, Your Honor, I'll draft the order. I just want to summarize your ruling so that I get it right the first time.
Right.
I'm going to prepare an order that requires both parties to submit to substance abuse evaluation and a hair follicle test as recommended by the friend of the court. I'm sorry, as directed by the friend of the court. That's number 1. Number 2, you're referring the parties in the family to the friend of the court for a custody and parenting time evaluation. Number 3, for counseling for the children, you're ordering us to submit a list, our proposed list, to the court and exchange those lists within 2 weeks of today. And if we have any objection to the names suggested by the other side, we're to provide to you the reasons why. Number 4, we're going to use the court's Our Family Wizard template for the communication. Number 5, the parenting time schedule includes the prohibition that neither party will consume alcohol or substances during their parenting time. Father's parenting time will be every Thursday overnight and alternating from after school until return to school on Friday morning, and on alternating weekends, including Friday after school, pick up until Monday school resumption. And then the court stated it's dicta. If that does not go well, the court will entertain a motion to modify that, depending on the children's adaptation to that. Further, you're ordering the mother and the father to submit to random drug and alcohol testing each week. That random testing would have to be at a time that they have the children in their care, correct?
Correct.
And to share the results with each other and the court I'm not clear as to what the testing facility will be. I'm sorry.
I was gonna take a look at that and let everybody know which one.
Okay. Okay, I'll put that in, that the court will order the testing lab. And then with
Ms.
respect to-
Badalucco, I think, had something she wanted to say.
I'm sorry.
Consultation regarding the parenting time, I heard something added in there about it may come back to the court depending upon the children's adaptation to that. That is not what the court said to my recollection. I think
Well,
the-
I will just, that was dicta. That doesn't need to be in the order.
I won't put it in the order.
All right.
And then the court will order, under the 7th paragraph, the court will let us know which testing lab for the random testing per week for each parent when the children are in their care. With respect to holidays, we will address the holiday schedule in upcoming mediation. And finally, I think that's it. That's what I've got for my notes. Ms. Badalucco, did I get that right?
Your Honor, we would prepare the order, but I'm assuming the schedule goes into effect immediately.
Yes.
Thank you.
To that point, then, I believe that Father had last weekend, some other would have this weekend. Is that correct?
Yeah, it's his birthday today, and I know that we previously agreed that he could have the overnight until tomorrow at 11 a.m. Is that still permitted?
Yes.
Yes. And so for specifically for this week, even though this would be Mother's Weekend in their rotation schedule, today's Father's birthday, so Father will have the children overnight from after school until what time?
Saturday at 11? Was it?
Saturday. Yes. And then Mother will have the rest of this weekend. And then next weekend, the weekend of the 20th, will be Father's Weekend, which will start on Thursday overnight. Yep. Okay.
All right. I think Ms. Badalucco said, okay, but I was reading her lips. I couldn't hear her.
You did say okay. Thank you. Your Honor.
Okay. All right.
Thank you very much, Your Honor. I'll submit the proposed order to Ms. Badalucco for her review and approval, and we'll await your ruling on where the random testing will be. And we will, the court will also refer the matter from the bench with its court order for the custody evaluation and
Oh,
the
yes.
drug.
And that the parties pay 50% each of the fee.
Okay, great.
Your Honor, thank you very much for your time this morning.
You're welcome.
Thank you.
Thank you, Your Honor.
We're adjourned.
Thank you.